Several of you forwarded to me a story about Delta-8 THC products becoming federally legal, just like hemp, says an appeals court. So I looked up the case and thought we should talk about this. The judge does a really good job of summarizing everything. What is Delta-8? How is it legal or not legal? What are the challenges to its legality? So I'm going to just jump right into it. This is AK Futures versus Boyd Street. This is a 4-publication decision. This is a precedential decision of the Ninth Circuit Court of Appeals. So this should be good law in the Ninth Circuit and potentially elsewhere. Of course, this is not individualized legal advice, so if you are going to do what AK Futures and Boyd Street Distro did, then you can discuss with your own attorney, because there are still complications in the world of pharmaceuticals, put it that way. AK Futures, LLC, a manufacturer of popular e-cigarette and vaping products, brought suit for trademark and copyright infringement against Boyd Street Distro, LLC, a downtown Los Angeles storefront and smoke products wholesaler. According to AK Futures, Boyd Street has been selling counterfeit versions of its Cake-branded e-cigarette and vaping products containing Delta-8 tetrahydrocannabinol, Delta-8 THC, a chemical compound derived from hemp. Boyd Street contends that AK Futures does not have a protectable trademark for its cake products because Delta-8 THC remains illegal under federal law. Faced with AK Futures' request for a preliminary injunction against the distribution of Boyd Street's products, the district court held that the 2018 Agricultural Improvement Act, the Farm Act, legalized the company's Delta-8 THC products, and the judge granted injunctive relief. Plain statutory text compels the conclusion that AK Futures products are lawful, and we see no other reason to deny the preliminary injunction. We affirm. Background. AK Futures is a producer and distributor of e-cigarette and vaping products. This suit involves the company's Cake-branded Delta-8 THC products. Delta-8 THC is a chemical compound that occurs naturally in the cannabis plant, Cannabis sativa L, which can be grown into either hemp or marijuana, alternatively spelled marijuana, depending on the cultivation method. According to the Food and Drug Administration, Delta-8 THC has the psychoactive and intoxicating effects similar to Delta-9 THC, which is the more traditional, the one everybody talks about when you smoke marijuana. That's the THC that everybody knows. It's a different chemical compound and the main psychoactive component of marijuana. The FDA notes that Delta-8 THC is not found in significant amounts in the cannabis plant. As a result, concentrated amounts of Delta-8 THC are typically manufactured from hemp-derived cannabidiol. In 2018, Congress passed and the president signed the Farm Act, which legalized the possession and cultivation of hemp. So one of the distinctions is going to be the difference between hemp and, I guess, marijuana. Because hemp and marijuana are different varieties of the same plant, the Farm Act uses the concentration of Delta-9 THC to set a threshold distinguishing the two. As defined by the Act, hemp includes any part of the plant, Cannabis sativa L, and all derivative extracts and cannabinoids, whether growing or not, with a Delta-9 THC concentration of no more than 0.3% on a dry weight basis. The Act is silent with regard to Delta-8 THC. AK Futures manufactures flavored e-cigarettes liquid containing Delta-8 THC, which it describes as a hemp-derived product with less than 0.3% of the psychoactive Delta-9 THC compound. According to the company, its products come with a QR code permitting verification of the percent of THC in the e-liquid less than 0.3%. The company also states that it regularly tests its products for potency and regulatory compliance purposes and screens for heavy metals, pesticides, and other contaminants. In October of 2020, AK Futures devised the Cake brand, a logo depicting a two-tier cake overlaid with a stylized letter C to market its Delta-8 THC products. I think this is it, the one on the right there. The company registered this cake logo with the Copyright Office. It also has pending trademark applications for 6 marks, 4 of which are various permutations of the word cake, and 2 are versions of the logo. So that's kind of consistent with what we're seeing here. All trademark applications are for use in connection with e-cigarette liquid cartridges and delivery systems. The cake name and logo appear on the packaging of the devices. AK Futures avers that its cake products are extremely popular, generating $60 million in revenue over a 9-month period. AK Futures learned of counterfeit versions of its cake e-cigarette products being sold by Boyd Street, a smoke products wholesaler and storefront in downtown Los Angeles, over the summer of 2021. There you have it, Boyd Street Distro. There you go, Boyd Street Distro. That is the storefront that we're talking about. Boyd Street is not one of AK Futures' authorized retailers. Suspecting infringement, AK Futures hired a private investigator to visit Boyd Street and purchase the purported cake products. AK Futures' packaging manufacturer compared the cake products obtained from Boyd Street to the AK Future originals. And despite a strong resemblance between the two, it observed differences in packaging materials, labeling, and color. It concluded the cake products sold by Boyd Street were inauthentic. As part of the case, AK Futures has submitted images showing its own cake e-cigarette products and packaging next to virtually identical counterfeits. Let's find that now too. All right, here's an example. The authentic packaging is on the left and the alleged counterfeit packaging is on the right. It's a pretty good counterfeit. The counterfeit's packaging is laminated with a thin layer. AK does not laminate its packaging. The counterfeit is made from thermos mechanical pulping paper, which has a yellow tinted middle layer. AKF does not use TMP paper. Counterfeits have copies of a certificate of analysis sticker on the back, which is copied from a prior version of a certificate used by AKF. The corners of the sticker differ from authentic, etc., etc. So they figured out that they're counterfeit. Boyd Street claims it had only 2 interactions with cake-branded products. The first involved an unidentified someone approaching the store and selling cake products on consignment. Boyd Street does not have checks or receipts for these sales. According to its CEO, the store conducts most of its business in cash. The second entailed Boyd Street making a purchase from a person who told the CEO they were an authorized distributor of cake products. The CEO states that his usual method of verifying a seller's authenticity is to ask for an invoice. Boyd Street claims its entire inventory of cake products has been sold and that it has no plans to sell cake products in the future. AK Futures brought suit alleging copyright infringement and federal unfair competition and false designation under the Lanham Act or Trademark Act. The company moved for a preliminary injunction, so they want an injunction preventing Boyd Street from selling cake products. Boyd Street initially failed to file a motion in opposition, so the district court entered the preliminary injunction without hearing from the store. The court enjoined Boyd Street from selling goods bearing imitations of AK Futures' 2 cake logo trademarks or any copy or colorable imitation of the company's cake trademarks. In a separate section of the order, it enjoined Boyd Street from reproducing, distributing, or displaying copies of the copyrighted cake design. After allowing Boyd Street leave to file and considering both parties' submissions, the district court issued an amended order and opinion, keeping the injunction in place. Reciting the facts, the district court's opinion ultimately agreed with AK Futures that, on the available record, its products are lawful under the Farm Act. Boyd Street timely appealed. Discussion. Appealing the preliminary injunction, Boyd Street does not contest the district court's finding that it was selling counterfeit versions of AK Futures cake products, so this is now established for the record of the case. Boyd Street has conceded that it was selling counterfeit versions of AK Futures cake products. Instead, Boyd Street's chief argument is that AK Futures could not own a valid trademark in connection with these products because federal law forbids the possession and sale of Delta-8 THC. So they're saying Delta-8 THC, the very product that they were selling, is illegal and therefore trademark law can't be used to protect an illegal product. AK Futures responds that the Farm Act legalized Delta-8 THC and, by extension, its products incorporating the compound. We agree with AK Futures, says the court, and we hold the district court properly issued a preliminary injunction. AK Futures is likely to succeed on its trademark claim because its Delta-8 THC products are not prohibited by federal law, and they may therefore support a valid trademark. AK Futures sought a preliminary injunction to prevent the infringement of its 6 unregistered trademarks under 15 U.S.C. 1125A. This provision forbids, in connection with any goods or any container for goods, the use in commerce of any word, term, name, symbol, or device that is likely to cause confusion as to the origin of the relevant goods. An infringement action for unregistered marks requires a plaintiff to show, among other elements not contested on this appeal, ownership of a valid protectable trademark. To own an unregistered mark, the plaintiff must be the first to use the mark in commerce, and such use must be lawful. Only lawful use in commerce can give rise to trademark priority. This rule prevents the absurd result of the government extending the benefits of trademark protection to a seller based on actions that the seller took in violation of that government's own laws. And it favors sellers who take the time to comply with government regulations before bringing products to market. At the same time, we have explained that illegal activity of insufficient gravity or connection to a mark's use in commerce might not defeat an otherwise valid trademark. The parties dispute whether the possession and sale of Delta-8 THC is permitted under federal law and, consequently, whether a brand used in connection with Delta-8 THC products may receive trademark protection. AK Futures argues that Delta-8 THC falls under the definition of hemp, which was legalized by the 2018 Farm Act. Boyd Street argues a contrary interpretation of the act based on agency documents and congressional intent. To evaluate these divergent claims, we first look to the text of the Farm Act before assessing Boyd Street's contentions. The Farm Act, the plain text. When engaging in statutory interpretation, we start where we always do, with the text. As we explain further, the plain and unambiguous text of the Farm Act compels the conclusion that the Delta-8 THC products before us are lawful. The relevant portion of the Farm Act removes hemp from the definition of marijuana in the Controlled Substances Act of 1970. Specifically, the term marijuana means all parts of the plant Cannabis sativa L, but does not include hemp. So though marijuana remains a Schedule I controlled substance, hemp has now been removed from Schedule I. Likewise, although Schedule I continues to list tetrahydrocannabinols, it now exempts tetrahydrocannabinols in hemp. Both of these sections reference the same statutory definition of hemp. We therefore turn to this definition. The Farm Act's definition of hemp represents the crux of the parties' disagreement, and so we quote it in full. The term hemp means the plant Cannabis sativa L, and any part of that plant, including the seeds thereof, and all derivative extracts, cannabinoids, isomers, acids, salts of isomers, whether growing or not, with a Delta-9 THC concentration of not more than 0.3% on a dry weight basis. Before interpreting this statutory language, we observe that the Drug Enforcement Administration has incorporated this definition into its regulations. Now, this is going to be important. These are agencies. The Drug Enforcement Administration, the Food and Drug Administration, these are executive agencies that are part of the executive branch of government and therefore only have the powers given to the executive branch of government to enforce the law. When the legislative branch makes an act, a law, legislation, when the legislative branch makes a law like the Farm Act, that should overcome any agency executive interpretation of the law, because now Congress has made the law. The law will trump any executive interpretation of the law. The entry for tetrahydrocannabinols on the DEA's regulatory Schedule I exempts any material, compound, mixture, or preparation that falls within the definition of hemp set forth in 7 U.S.C. Section 1639, letter O. and the DEA's entry for marijuana extract mirrors the terms of the Farm Act's definition. AK Futures argues the Farm Act's definition of hemp encompasses its Delta-8 THC products so long as they contain no more than 0.3% Delta-9 THC. Plain meaning supports this interpretation. A straightforward reading of Section 1639 letter O yields a definition of hemp applicable to all products that are sourced from the cannabis plant, contain no more than 0.3% Delta-9 THC, and can be called a derivative extract, cannabinoid, or one of the other enumerated terms. Importantly, the only statutory metric for distinguishing controlled marijuana from legal hemp is the Delta-9 THC concentration level. In addition, the definition extends beyond just the plant to all derivatives, extracts, and cannabinoids. The use of all indicates a sweeping statutory reach. The common meaning of the word all is the whole amount, quantity, or extent of, as much as possible, quoting the Merriam-Webster dictionary. This seemingly extends to downstream products and substances as well, so long as their Delta-9 THC concentration does not exceed the statutory threshold. Certainly, a substance must be a derivative, extract, cannabinoid, or one of the other enumerated terms to fall within the Farm Act's statutory definition. However, these terms do not impose meaningful constraints. We may consider whether a term carries a technical meaning in a particular context. For instance, in the Van Buren case, a case concerning the Computer Fraud and Abuse Act, the Supreme Court considered the technical meaning of the term access in the computing context. Here, the various terms of Section 1639 letter O all have technical meanings in the chemistry context, but these meanings are themselves broad. See the definition of cannabinoid from the Oxford English Dictionary, any of a group of substances including cannabinol, cannabidiol, and other structurally related compounds of natural and synthetic origin. Thus, even in the chemistry context, the terms of the Farm Act's definition of hemp capture a wide variety of potential substances and products. On the available record, the Delta-8 THC in AK Futures e-cigarette liquid appears to fit comfortably within the statutory definition of hemp. According to the company's uncontradicted declaration, its Delta-8 THC products are hemp-derived and contain less than 0.3% of Delta-9 THC. The FDA materials cited by Boyd Street also refer to Delta-8 THC as one of over 100 cannabinoids produced naturally by the cannabis plant. This indicates that the Delta-8 THC in the e-cigarette liquid is properly understood as a derivative, extract, or cannabinoid originating from the cannabis plant and containing not more than 0.3% Delta-9 THC. AK Futures is thus likely to succeed in showing its products are not illegal under federal law and are eligible for trademark protection. The conclusion that AK Futures Delta-8 THC products are lawful necessarily depends on the veracity of the company's claim that these products contain no more than 0.3% Delta-9 THC. A showing that AK Futures products contain more than the permitted threshold level of Delta-9 THC would defeat AK Futures' entitlement to trademark protection. According to the DEA and FDA, many cannabis-derived products do not contain the levels of cannabinoids that they claim to contain on their labels. So it is entirely possible that AK Futures may ultimately fail to show that its products stay within acceptable Delta-9 THC limitations. But at the preliminary injunction stage, the beginning of the case, we must assess likely success, and the only probative record evidence is AK Futures' statement that its products contain less than 0.3% Delta-9 THC. Further evidentiary support is not required at this stage. See the K2 Ski Company versus the Head Ski Company case, a Ninth Circuit Appeals Court case from 1972, quote, "A verified complaint or supporting affidavits may afford the basis for a preliminary injunction unless they consist largely of general assertions which are substantially controverted by counter-affidavits." Along with its complaint and motion for an injunction, AK Futures has provided a sworn declaration that remains uncontradicted regarding the factual particulars of its Delta-8 THC products. This is sufficient to obtain an injunction. On to Boyd Street's counter-arguments. Boyd Street advances two principal arguments that the legalization of hemp in the Farm Act does not extend to Delta-8 THC, neither of which overcomes the clear statutory text, says the court. First, Boyd Street argues the DEA has interpreted the act not to apply to Delta-8 THC because of the compound's method of manufacture or concoction. Second, it argues that Congress never intended for the act to legalize any psychoactive substances such as Delta-8 THC. Both arguments fail. I continue to find it amusing that Boyd Street is arguing that they can't sell the Delta-8 THC products that they were in the business of selling. Boyd Street argues that, according to the DEA, Delta-8 THC remains a Schedule I substance because of its method of manufacture. Boyd Street relies on the DEA's explanation of its implementing regulations. It points to the phrase, quote, all synthetically derived tetrahydrocannabinols remain Schedule I controlled substances. According to Boyd Street, Delta-8 THC is synthetically derived because it must be extracted from the cannabis plant and refined through a manufacturing process. In Boyd Street's view, Delta-8 THC is considered a synthetic cannabinoid by the DEA because, among other things, it is concentrated and flavored. Although we disagree with Boyd Street on the DEA stance, we need not consider the agency's interpretation because Section 1639O is unambiguous and precludes a distinction based on manufacturing method. Clear statutory text, legislation overrides a contrary agency interpretation. The Farm Act's definition of hemp does not limit its application according to the manner by which the derivatives and extracts and cannabinoids are produced. Rather, it expressly applies to all such downstream products so long as they do not cross the 0.3% Delta-9 THC threshold. While this statutory definition is broad, its breadth does not make it ambiguous. Consequently, determining the scope of the Farm Act's legalization of hemp is not a situation where agency deference is appropriate. So we don't choose the agency over the legislature, we choose the legislature over the agency when there is a conflict of legal interpretation. The DEA does not appear to agree with Boyd Street as to what makes a cannabis product synthetic and thus unlawful. In the same passage quoted by Boyd Street, the DEA explains the Farm Act does not affect, quote, the control status of synthetically derived tetrahydrocannabinols because hemp, as derived by the statute, is limited to materials that are derived from the plant Cannabis sativa L. This language suggests the source of the product, not the method of manufacture, is the dispositive factor for ascertaining whether a product is synthetic. A recent agency letter bolsters this understanding. There, the DEA clarifies that synthetic Delta-8 THC is produced from non-cannabis materials, and thus that synthetic Delta-8 THC remains banned. In short, the DEA appears to understand the Farm Act's definition of hemp in the same manner as this court. In sum, the Farm Act's definition of hemp is not ambiguous, and we do not consider agency interpretation. Even if we did, the DEA's view of the Farm Act's plain text aligns with our own and does not support Boyd Street's proposed distinction based on manufacturing method. Boyd Street next argues Congress intended the Farm Act to legalize only industrial hemp, not a potentially psychoactive substance like Delta-8 THC. As evidence, it quotes from statements in the legislative history referring to industrial hemp. The December 12, 2018 statement from Representative Comer, I am particularly glad to see industrial hemp descheduled from the controlled substances list. Boyd Street is effectively asking us to recognize the following limitation, that substances legalized by the Farm Act must somehow be suited for an industrial purpose, not for human consumption. Unfortunately for Boyd Street, this limitation appears neither in hemp's definition nor in its exemption from the Controlled Substances Act. The term industrial hemp does not appear in a separate section, modifying previously enacted authorization for research into the plant. But the relevant U.S. Code provision contains its own definition of industrial hemp that is even broader than the one we have considered so far. To give effect to Boyd Street's understanding of congressional purpose, we would need to read its proposed limitation into the statute. But courts will allow neither ambiguous legislative history nor speculation about congressional intent to muddy otherwise clear statutory language. Regardless of the wisdom of legalizing Delta-8 THC products, this court will not substitute its own policy judgment for that of Congress. If Boyd Street is correct, and Congress inadvertently created a loophole legalizing vaping products containing Delta-8 THC, then it is for Congress to fix its mistake. Boyd Street's intent-based argument is thus unsuccessful. With that, neither of Boyd Street's counterarguments dissuade us from the conclusion that AK Futures is likely to succeed on the merits of its trademark claim. We are left with Boyd Street's remaining challenges to the injunction on other elements. And long story short, they don't win those either. Boyd Street suggests that Delta-8 THC is potentially unsafe for consumers. They were selling it. So an injunction protecting marks used in connection with these products may never be in the public interest. But Boyd Street misunderstands the nature of trademark law. Agreeing with Boyd Street at this stage would not keep Delta-8 THC products off the market. Rather, it would let a store continue to sell counterfeit versions of unknown origin. AK Futures has staked its name and reputation on the safety and quality of its cake-branded products. A trademark is a sign of the quality of an article. A brand name may also be an assurance of quality. These protections of trademark law mean that AK Futures does not need to do the same for the untested products of other companies. When there is trademark infringement, the reputation for quality enjoyed by the senior user is now in the hands of a stranger, the infringer. And these protections allow consumers to distinguish between brands that take consumer health seriously, as AK Futures declares that it does, and those that do not. Conclusion: the record on appeal convinces us that AK Futures Delta-8 THC products are lawful under the plain text of the Farm Act and may receive trademark protection. As we have noted, this conclusion is necessarily tentative given the nature of preliminary relief. We're at the beginning of the case. Yet Boyd Street fails to persuade us that the district court should not have issued an injunction. Therefore, we affirm the grant of the preliminary injunction in AK Futures' favor, and we remand for further proceedings. So that's interesting, and for people who want to consume Delta-8 THC products, well, you are not barred at the federal level at this time, according to the Ninth Circuit Court of Appeals. So you're probably safer if you are in the Ninth Circuit Court of Appeals and your state does not have a state law against Delta-8 THC. If you're outside the Ninth Circuit Court of Appeals, this case doesn't necessarily apply to you. It might be persuasive argument, but it won't be binding legal precedent in states and territories outside of the Ninth Circuit. So if you consume these products, good luck figuring out if they're legal for you, but here's at least the Ninth Circuit explaining that it's not illegal at the federal level. Let me know what you think of this case. Let me know what you think of the whole Delta-8 THC sort of cat and mouse game of legalization versus not legalization. Let me know your feelings about marijuana legalization in general in the comments below. Thanks for watching. Special thanks to my top supporters in May: John Steele, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, Gutbrodj, ShadowTycho, Earthbound Star, PureMagma, Eric Tams, TechTechPotato, The Blood-Soaked Survivors, Wyatt Calandro, and King Aries. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for my weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye.